In business, plans don't always unfold exactly as expected. A project may be delayed, cash flow may tighten, or your overseas lender may propose adjusting the repayment terms to reflect changing market conditions. Whatever the reason, you may find yourself needing to restructure an existing foreign loan. What many businesses don't realize, however, is that changing the terms of a foreign loan is not just a private negotiation between borrower and lender. In Vietnam, foreign loans are regulated, and restructuring them is a legal process, not just a commercial one. In this video, we'll explain how to legally restructure a foreign loan in Vietnam, which changes typically require registration, and how to stay compliant while still giving your business the flexibility it needs. Let's first clarify what loan restructuring means in practice. Under Vietnamese regulations, restructuring generally refers to any change to the key terms of a registered foreign loan. This can include changes to the loan amount, the interest rate, the repayment schedule, the loan duration, the currency, or even the method of disbursement or repayment. When these core terms are adjusted, the authorities may treat the change as a material amendment to the original loan. And that's important, because material changes often trigger an obligation to register the amendment with the relevant authorities. Even something that seems minor, like extending the loan maturity by a few months, can have compliance implications if it is not handled properly. So which types of changes usually require registration, and which ones may not? In general, registration is typically required when restructuring involves changes such as extending the loan term, increasing or decreasing the total loan amount, adjusting how interest is calculated, changing the identity of the borrower or lender, or switching the bank account used for repayment. Any amendment that affects the core structure of the original loan is likely to fall into this category. On the other hand, very minor operational adjustments, for example, slight shifts in repayment dates by a few days, or small changes to bank fees, may not always require re-registration. That said, there's one principle we'd always recommend following. When in doubt, check first. Failing to register a change that should have been registered can place the company in a non-compliant position, even if the underlying business intent was reasonable. Timing plays a crucial role in loan restructuring. Under Vietnamese regulations, changes to a registered foreign loan generally need to be filed within a statutory period from the date the amendment takes effect, or from the date the amended agreement is signed. If that deadline is missed, companies may be required to provide explanations and could face additional scrutiny, particularly during audits or when making cross-border payments. The safest approach is to plan ahead. Where possible, register the changes before they take effect. This helps ensure that your documentation, banking transactions, and regulatory records remain fully aligned. To make this more concrete, here are a few real-world scenarios we frequently see. In one case, a company renegotiated its interest rate with an overseas lender after market conditions shifted, which required updating the registered loan terms. In another, a client extended a loan from 18 months to 30 months due to project delays, triggering the need to register a revised maturity date. We've also assisted companies that changed the repayment currency, for example, from US dollars to euros, to better match their revenue streams. Each of these changes made commercial sense, but all of them required proper legal steps to remain valid in Vietnam. So what happens if a loan is restructured, but the changes aren't registered? In some cases, banks may block transactions and request updated regulatory confirmation. In more serious situations, companies may face administrative penalties, compliance flags, or increased attention during tax inspections. There's also a legal risk to consider. If the amended loan terms are not properly recognized under Vietnamese regulations, it may weaken the company's position in the event of a dispute with the lender. The takeaway is simple: if you change the loan, make it official. At LTS Law Firm, we regularly assist foreign invested companies with foreign loan restructuring in Vietnam. Our team works closely with clients to review amended loan terms, assess whether registration is required, prepare and translate the necessary documents, submit filings to the authorities, and coordinate with banks to ensure smooth implementation. We also help structure loan amendments in a way that aligns with Vietnamese regulations from the outset, reducing the risk of issues later on. The goal is always the same: compliance without unnecessary disruption to your business. If your company is considering changing the terms of a foreign loan, or has already done so, it's important not to assume the paperwork will take care of itself. Reach out to LTS law firm for clear, practical guidance on how to restructure your foreign loan legally in Vietnam. We'll help you identify which changes need registration, prepare the required filings, and ensure your restructuring is fully compliant. Visit www.lts.com.vn or contact our legal team today. A flexible loan can be a powerful business tool, but only when it's structured and restructured the right way.